and I'm a Hartford attorney, and I represent Avery and her mom, Lauren. And the facts about this case are sort of synopsized. I think Andy used the term Reader's Digest version is in the back of that program. So I don't see any reason for me to sort of run through the case with you. But what I wanted to do is at least explain why, as a lawyer, I think this case is so important, not only for civil libertarians in general and those that favor free speech, but for all students in particular. Without getting to any detail about how the First Amendment applies in general to high school students, one should know that the United States Supreme Court over many years has said that the right of a school to control what students say or write or protest stops at the schoolhouse gate. Now, you know, the notion of a schoolhouse gate is very quaint. Most schools don't have gates anymore. Is this better? And what I want to emphasize is that up until the age of the internet, the school had no right to tell students anything about what they said at home, what they published. They could publish underground newspapers. They could criticize the school. They could say anything they wanted, even something vulgar or crass about the school administrators, and could not be subject to punishment. Here comes the internet and the notion of blogs and instant messages and emails. And as far as those of us who believe in the First Amendment, nothing's changed, but the school has, and the schools in general and those in charge have taken a different view and said, okay, we now have another opportunity to control what students say, perhaps even what they think and write while at home. And they've done that by arguing that the internet is so all-pervasive. It reaches into the school. It reaches into the homes, whether you like it or not. And therefore, we have an opportunity to censor what students say or do or write while at home. Now, I happen to disagree with that. A lot of people disagree with that. What you need to understand is that even in school, the school administrators can only take action against students if what they say or write tends to disrupt the school. And I want to emphasize, substantially disrupts I think the term is pedagogical interests of the school, which is a fancy way of saying, you know, the running of the school, the running of the school administration. Other than that, students can wear T-shirts. They can say Team Avery. They can say support Lewis Mills High School free speech, and they cannot be sanctioned for it. The school, however, and this particular federal judge has now, however, suggested that what you write on the internet can come back and be used against you if you're a student involved in some kind of extracurricular activity. They did not suspend Avery for what she wrote, but instead they took away one of her titles. And the way the case is written, it could apply whether you're on a sports team, whether you're on the school newspaper, whether you're in the school play. But I suggest could it go even farther than that. Privileges in school include parking passes, right? It's a privilege. They can take that away. Going to graduation. There is a danger here that students can lose all of their right to free speech. And that's why this case, in particular, it's not what Avery said in particular, what Avery said in her blog, but the fact that the school could take action against it, which, at least in my mind, is scary. And therefore, we are appealing. The case is pending in the Federal Court of Appeals in New York, which covers Connecticut and a couple of other states. And we're asking that court to overturn the decision by Judge Kravitz and essentially issue an injunction that returns Avery to her position as class secretary, which she, in fact, won, even though she was barred from the ballot. So I urge you all, I thank you all for being here. I thank you for supporting the notion of free speech. And one should know that filing an appeal is expensive. You have to publish pre-printed briefs that have to be filed. Numerous copies have to be filed. Transcripts cost several $1,000s. And of course, you're all welcome. The case is going to be scheduled for argument in December, January in New York City at the Federal Court of Appeals, and you should all maybe come down if you're interested for that argument. Thank you very much.